right, good afternoon, and we are back here for this presentation. We're going to be talking about leveraging trial exhibits with technology and using technology in the courtroom. Before we do that, a little bit about myself. My name is Armand Murach. I am one of the partners at the Rossen Law Firm. I've been working in litigation for over a decade, focusing mainly in criminal defense and criminal prosecutions. But I have done everything from business litigation, family law, federal courts, civil rights defense, and those types of different cases. I've also been an instructor at several law schools. I've taught at state attorney's offices, prosecutors' offices, public defender offices. My local bar association is a presentation I'm going to be doing quite shortly. And I've also been an instructor for the National Institute of Trial Advocacy. And the design of that for how you present it to someone and and understanding the psychological effects of how the brain works can help you sneakily make that impact larger than just plopping up an image on a screen, on a projector, or on a foam board or poster board to a jury. So it's gone to a much more high technical level to present that information and also present it in a way that is palatable to the person. So a lot of times when you're looking at more complex litigation, let's say a business litigation where a lot of contracts or Excel spreadsheets are involving massive amounts of data, you have to sort of break that information down. And using trial exhibits is the way to do it in a way that a person can remember it. A lot of people have difficulty with numbers. You always hear people say, oh, they can't remember numbers. The old colloquial for lawyers, like if lawyers were good at math, they wouldn't be lawyers. That sort of rings true for a lot of people, where numbers basically make people not remember things, not be able to retain that information and why those numbers should be important. And being able to process that information visually through trial exhibits helps the person be able to comprehend, understand that, and make a decision based on that information. Because you cannot depend upon someone to be able to process volumes and volumes of numbers, contracts, paragraphs, clauses, what it may be within those complex litigation cases for them to be able to remember, weeks or even months down the line when they're deliberating in a jury room and all they have is those same pages that you presented them without the argument being able to attach or connect to that person when they're trying to make that decision at the end of that trial when they're deliberating in a room. And that's sort of the key thing that a lot of lawyers miss because we don't know what's going on in a jury room. But if you effectively present trial exhibits of the information that you're trying to argue throughout your trial, and most importantly within your closing argument, it creates a sort of safety net for you to understand that the jury understood what's going on through the cues that they present to you, nodding their head to that information rather than dozing off, which is sort of the linchpin where people get scared when it's in terms of people not being able to pay attention for long periods of time and understand when those crucial points within the trial are for them to be paying attention. I used to like to say that, like with Twitter, it needs to be at 120 characters at a time. And that's sort of a gross estimation as to how someone is going to be able to process that information, but it's a good guideline of how to sort of spoon feed and slow down the absorption so that bandwidth is not being overloaded. Again, that sensory overload that people can get at any point during a trial. Because when they get to that point of having sensory overload, then they're just going to stop listening and then they shut down. And it's not because they're willingly wanting to do that, but that's just because their brain can't process anymore of what you're giving them. So it's sort of that old adage where you're highlighting those important facts, but you have to present everything still to a jury for them to understand the whole picture. So just highlighting may not be enough. So that's why you sort of distill the information, you slow feed it to a jury, you slow feed it to the witness even that's trying to give you and help you during that trial to be able to better comprehend that type of information. So one of those examples here, and I've sort of been talking about this, is when you have something that's a spreadsheet that has 15 million pages on it because it's a corporate document from an SEC filing or something along those lines, and you need to present numbers, facts, figures, revenue earnings, those types of information. Being able to distill that information into, let's say, a bar chart, a pie graph, even a Venn diagram, is able to sort of distill information for a jury to understand everything that is in that fact. And some of the sub points that you look at when you're looking at this is charts and graphs to simplify complex data. This is what we were talking about earlier, using spreadsheets that are being entered into evidence that present a lot of different information: cell phone records, bank records, business records. A lot of different business entities use spreadsheets. Excel is almost a common phrase when it comes to business litigation, when it comes to cell phone records, when it comes to bank records. Everything is sort of stored in spreadsheets to sort of present information in a neat, patterned way. But it's not the way that we can remember that data. So that's why visualizing that data is beneficial to help a jury understand it, rather than presenting it and arguing it for hours for someone to try to understand all of those pages that you're trying to argue, if that's the type of case you're dealing with. Annotated diagrams are also another important thing when you're trying to do summations or summaries of what's been presented. When you can sort of distill the information down to the nitty-gritty of the important facts, show the jury that you've gone from the large spreadsheets into something that is much smaller and succinct, because you're only looking for specific facts that are important to the trial that they're understanding. You clarify sort of the smoke and the basically letting the jury see beyond the trees and see the entire forest in the presentation of the argument that you're doing. And a lot of times this is sort of labeling medical diagrams, medical sheets, or doctor's notes from, let's say, a hospital stay. And those types of sheets, if you're doing those types of medical cases like a medical malpractice or a personal injury case, you'll see that there is voluminous amounts of documents. And a lot of times they're just form-based that have a lot of information on them, and there may be only a few check marks of that document that are important to you. But the fact is, you won't want to present a 8x11 sheet of paper that has so many different points of information on it that are not important to you. And a lot of times, this can cause confusion of a jury not understanding or melding two different timelines together to basically come up with their own version of events. Now, you talk to any trial attorney, any seasoned attorney, and they will tell you, you never leave anything to chance to a jury for letting them reach a conclusion or decision, because you don't know what they're thinking. So you always want to spoon feed it to them through these types of trial exhibits so that they understand exactly what's going on. But the thing you want to be careful about is when you're doing this is to do comparisons. And I mean that in two ways: one substantively and one for your own benefit, to make sure stuff doesn't get excluded. So the first thing is sort of before and after comparisons. And a lot of times there's old technologies that this has sort of been around for decades, and how lawyers have gone about that. And we'll talk about that technology portion in a little bit. But a lot of times it's important to show how someone has changed. This is important in cases involving basically personal injury or corporate structure. So when you're dealing with corporate litigation or sort of financial situations in terms of accounts and different accounts being spread over for someone in a family law case, being able to visually show that representation in terms of numbers of accounts, in terms of injuries to a person, how they walk in comparison from before and after through side view videos of, comparison on the difference of how they've been affected, is really sort of the important aspect in determining, a comparison visually. So someone who's never met this person before can be able to interpret how they walked before and how they're walking now. And it's sort of the best way of presenting that type of information. The other thing to think about is also how much of a difference your demonstrative evidence is being presented to a jury. So you don't want to go overboard. You don't want to present this information where it's completely become biased towards the other side, or it's sort of unfair, because you're going to be sort of limiting, or you're going to be creating objections to yourself and how you present that. So it's important to consider the technology that you're using to effectively communicate these exhibits.